Good afternoon, and welcome to our discussion on Chevron Deference. My name is Eugene Laney. I'm the President and CEO of the American Association of Exporters and Importers. We would like to thank Sandler, Travis, and Rosenberg for sponsoring. Before I introduce our speaker, we have some housekeeping notes. You can learn more about our speaker in our resources tab at the bottom of the screen. To keep the dialogue going, we would encourage you to submit questions that can be covered at the end of the program by our speaker. Our speaker, Jason Kenner, is a member of Sandler Travis Rosenberg's lead litigation practice, specializing in customs and trade issues. Prior to joining STR, Mr. Kenner served as an attorney and senior trade counsel with the Department of Justice, specializing in customs and trade as well as trade fraud, the Trade Fraud Task Force. We would like to welcome Jason, and I'll turn it over to you. Thank
Thank
you.
you. Thank you, Eugene. And thank you, everyone, for joining us today. As Eugene explained, my name is Jason Kenner. And for about 15 years, I was with the Justice Department, and I handled customs and trade matters on the government side. And towards the last several years, I was on the Trade Fraud Task Force and specialized in investigating and prosecuting trade violations under 592. But that's not what we're here to talk about today. We're here to talk about deference. So I guess we have an opening poll, and I guess we're going to find out how familiar folks are with Chevron deference. Okay, I guess let's go to the next slide and get started. So we have interesting. Majority are somewhat familiar, and many are not very familiar. And if several are very familiar. But in any event, we're here to talk about what Chevron deference is and what deference is in general. Next slide, please. Next slide. Next slide. Okay. I think to understand the potential impact of Loper Bright and its reversal of Chevron and its impact on customs compliance, I think we need to start with an understanding of what deference is. When does it apply? How does it apply? And how it can impact customs issue. Well, deference is a judicial principle that courts may defer to the interpretations or decisions of administrative agencies or their other government entities in specific circumstances. And I say it's a judicial principle because the issues arise in court cases where judges must evaluate the actions or policies of an agency. The theory behind deference, by and large, is and was the recognition that agencies have greater expertise in their niche areas than do judges. And interestingly, while I think that notion holds a lot of truth in a general district court that hears cases involving a whole myriad of government agencies, the CIT, or the Court of International Trade, which hears these customs and trade cases, is unique in that it is a district level court, but it's one of limited jurisdiction. It only hears customs and trade cases. And in my 18 years of practice before the CIT, I have found, by and large, that many of those judges understand customs regulations and statutes just as well, if not better, than the agencies. In any event, there are several levels of deference that have been applied to agency actions and interpretations. These include Chevron, which we're here to talk about today, but there's also others. There's Skidmore deference and Auer deference. And each of these levels of deference applies, or in the case of Chevron, applied in different scenarios and had different tests and applications and different implications. So why is deference an important issue? Well, deference can be outcome determinative of a court case. Meaning if a court accepts the government's interpretation of an ambiguous statute, it obviously gives the government an edge and likely can be outcome determinative. Further, if the government is given deference in court cases, for example, to its interpretations of statutes and potentially regulations, it obviously provides the government a degree of latitude in drafting regulations and interpreting regulations. So now that we have just a general understanding of deference, let's move into the pre-Lopez level of deference. And we're going to do these kind of in chronological order. Next slide, please. The first level of deference is called Skidmore deference, and it arises from Skidmore v. Swift. In the 1944 Supreme Court case, Skidmore v. Swift, firemen and elevator operators sued to be paid overtime for time spent on call at the fire hall, even when they were not actively responding to a call. The Department of Labor had provided guidance on how the Fair Labor Standards Act could be applied in these situations, and the DOL guidance suggested a flexible approach depending on the degree of personal activities employees could engage in during on-call time. In deciding the case, the court ultimately found that the Fair Labor Standards Act did not prevent waiting time from being counted as working time. Essentially, just because they were waiting, the firefighters were waiting, didn't mean the firefighters weren't working. And the court noted an important point regarding deference to agency interpretations. And they explained, and I'm quoting, "We consider that the rulings, interpretations, and opinions of the administrator under this act, while not controlling upon the courts by reason of their authority, do constitute a body of experience and informed judgment to which courts and litigants may properly resort for guidance." So you can see here, you're already starting to see the understanding that agencies may have a better understanding of their niche areas than perhaps a court. In any event, this case established what's now been called Skidmore deference. Under this standard, courts don't have to follow an agency's interpretations, and that's going to be something we're going to see a difference when we start talking about Chevron. But they may look to the agency's interpretations for guidance based on the agency's expertise and experience in a particular field. Next slide, please. And Skidmore deference is considered a lesser level of deference compared to others like Chevron and OR, which we'll talk about in a minute. But Skidmore deference applies in a situation where an agency's interpretation does not result from any congressional delegated authority. For example, it is used when the agency doesn't have explicit authority to issue binding regulations. Under Skidmore deference, the level of respect given to the agency's interpretation is proportional to its power to persuade, which is a bit of a circular argument. But in other words, the court considers how convincing the agency's reasoning is rather than being obligated to follow it. The court developed a set of criteria that are applied to determine whether or not Skidmore deference is going to be applied. And these include the thoroughness of the agency's position, the validity of the agency's reasoning, the consistency of the agency's interpretation over time, and any other persuasive powers the agency may have, and that would be their expertise in the area. In essence, Skidmore deference recognizes that the agency has expertise and experience, but ultimately leaves the court free to decide whether or not to adopt the agency's interpretation based on how persuasive that interpretation is. And we'll talk about a little later, but Skidmore deference was eventually applied to customs rulings in a Supreme Court case, and we'll talk about that again in a little bit. Next slide, please. So here we have Chevron deference, and this is a heightened level of deference over Skidmore. It stems from a 1984 Supreme Court case, and in that case, the core issue was the interpretation of the term source under the Clean Air Act of 1963. The statute didn't clearly define source, which led to questions about how strictly environmental standards should be applied to complex facilities with multiple units. The Environmental Protection Agency initially defined source to cover essentially any significant change or addition to a plant or factory. But in 1981, the EPA changed its definition to mean only an entire plant or factory. And this was important because it allowed companies to build new projects without going through the EPA's lengthy new review process if they simultaneously modified other parts of their plant to reduce emissions, and again, avoiding any net changes. The National Resource Defense Council, an environmental group, challenged the legality of the EPA's new definition, and Chevron intervened. After the DC Circuit initially ruled that the EPA's new interpretation of source conflicted with the circuit's prior case interpreting the term and that it was invalid, the Supreme Court ultimately upheld the EPA's interpretation. The court ruled when a statute is ambiguous, courts should defer to the agency's reasonable interpretation of the law. Next slide, please. And this decision led to what we call Chevron deference. And under Chevron deference, courts were required to defer to an agency's interpretation if the statute in question was ambiguous And two, the agency's interpretation was reasonable. Now, again, you can already start comparing this to Skidmore, which is not, the court isn't required to follow the agency's construction, but simply can look at its persuasive power. Here, if the statute is ambiguous and the agency interpretation is reasonable, that means the court was bound to follow the agency's interpretation. This means that when a statute doesn't directly address a specific issue at hand, the agency's interpretation would be upheld as long as it was a reasonable construction. And again, it didn't even have to be the best construction or the construction of the statute that the court would have come up on its own. Just be reasonable. This deference respected the agency's expertise in a specific area and allowed it to fill the gaps where Congress had left ambiguity. Essentially, Chevron deference ensured that as long as an agency's interpretation is logical and within the bounds of the statute, courts will typically support it rather than substitute their own interpretation. Again, even if the court does not believe it's the best interpretation. This gave the government very wide latitude in construing ambiguous statutes. Next slide, please. In Chevron, the case created a two-step framework. The first, has Congress directly addressed the issue? That was the first question the court had to determine. The first step requires that the court examine the statute's language to determine whether Congress had clearly spoken on the matter. If Congress's intent was clear and unambiguous, both the court and the agency must adhere to that intent, and no deference would be given to the agency's interpretation. Essentially, if the statute directly addressed the question, the agency had no authority to reinterpret or deviate from what Congress had explicitly laid out. However, as is the case many of the times, statutes can be ambiguous. And if the statute was silent or ambiguous, the next question was, well, is the agency's interpretation here reasonable? And if the statute is unclear or Congress hadn't directly addressed the issue, the court then assessed whether the agency's interpretation was reasonable. In this step, the agency's interpretation doesn't have to be the only possible reading or even the best one, as we explained before, just a reasonable one. And the courts under Chevron would generally uphold the agency's interpretation if it fell within a reasonable scope, even if the court might have preferred a different interpretation. So as you can see here, you have Skidmore, which is not mandatory, but now we had Chevron, which is mandatory if it's an ambiguous statute and a reasonable interpretation. And the last deference we're going to talk about today, next slide, is our deference. And this we'll just go through kind of quickly. We don't really have to talk about the facts of this case, but what it did was essentially applied Chevron deference to customs interpretation of its own, or any agency's interpretation of its own ambiguous statute or regulations. So you have Skidmore deference now that applies to customs rulings, for example. You had Chevron deference, which will apply to customs interpretation of ambiguous statutes, and then you have our deference, which is going to apply to customs interpretation of ambiguous regulations. So these are kind of the three levels of deference that customs get. Next slide. So then we have United States v. Meade, which is the actual Supreme Court case, which applied Skidmore deference to a CBP ruling. And the case involved Meade Corporation's challenge to customs classification of imported day planners as diaries, which subjected them to higher duties. The Court of National Trade found that prior CBP rulings, not even the ruling on the product, but a prior ruling on similar merchandise, was persuasive and ultimately granted the motion summary judgment on the classification issue. And Meade appealed to the CAFC. The CAFC reversed the CIT and determined that no deference should be afforded to CBP rulings for three reasons. First, rulings were not issued after notice and comment. Two, rulings did not carry the force of law. And three, rulings only applied to specific cases only, so it didn't apply across the board to importers. The government sought cert to the Supreme Court, and cert was granted. Next slide, please. And the Supreme Court agreed with the CAFC to the extent it held that Chevron deference does not automatically apply to all agency interpretations of statutes, and here specifically did not apply to a ruling letter. The Supreme Court explained that Chevron only applies when, one, Congress delegated authority to the agency to make rules or decisions with the force of law. Two, The agency's interpretation was made through a process that carries the force of law, such as formal adjudication or notice and comment rulemaking. In the case of a ruling letter, the court echoed the CAFC's sentiments that rulings did not meet these criteria. However, the court disagreed with the Court of Appeals that no deference should be afforded to the ruling letter, and it held that Skidmore deference could be appropriate and reiterated the under Skidmore, the weight given to an agency's interpretation depends on several factors, such as thoroughness of the agency's reasoning, the validity of its logic, the consistency of its interpretation over time, and the agency's expertise in this matter. And in addition to solidifying that customs rulings may be entitled to Skidmore deference, in deciding Meade, the Supreme Court created what became known as Chevron Step 0. As we talked about before, there was a two-part test before, and it was, is there an ambiguity in the statute, and was the interpretation reasonable? Now they've created Step 0, which is a determination of whether the agency was empowered by Congress to interpret the statute. If no, you never got to the other two steps in Chevron. So you already can see, as of Meade, they're already starting to try to cut back or curb Chevron's impact. Next slide, please. Want to take a quick moment just to talk about Meade, and I think it's a very good example for folks who are interested in deference and how it applies to ruling letters, which is still a very big issue in customs litigation and in customs compliance. Mattel involved a classification dispute for merchandise referred to as a pop-up wackaroo. If Mattel believed that the product should be classified as a game, while Customs classified it as a toy. Notable for this discussion is that Customs issued a ruling letter classifying the product prior to the court case. In its ruling, CBP determined that a game had four elements essentially, and that was: one, a competition or contest with the objective of winning; play activity between two or more people or between one person in the game itself; three, skill, chance, or endurance, or a combination of these elements; and four, a method of scoring. Now, CBP determined that the pop-up wackaroos were not games because all four of the elements were not satisfied, and in particular, element 4, which was a method of scoring. Now, Customs sought deference to its ruling letter in its motion for summary judgment. And then, deciding the case, the court was required to go through the Supreme Court elements. And it's therefore the court first examined Customs' reasoning in the ruling letter, and found that Customs did not adequately support its conclusion. The court found inconsistencies in Customs' reasoning, particularly in its reliance on rulings for goods that were materially different than pop-up wackaroos. The court then moved to the consistency of the interpretation, and the court found that Customs had classified very similar items under different headings in past rulings. So there was a lack of consistency. 3, logic and persuasiveness. The court then scrutinized the logic behind Customs' determination, and it found that Customs' rationale lacked clarity, especially given the same whacking motion used in the game was similar to other game machines previously classified as games. And finally, while the court acknowledged that CBP technically has expertise in the area of Customs classification, the court found that this could not be dispositive and did not overcome the first 3 elements that were not satisfied. And ultimately, the court did not afford the ruling deference, and ultimately the government lost the case. Again, the court didn't look at what was the ruling reasonable. Was it a reasonable interpretation of the tariff? Was it a reasonable interpretation of game? No, it looked to those 4 factors. It was able to kind of drill down a little bit more and determine that no deference was to be afforded. And interesting aside is, if you type Skidmore into cross ruling letters, you'll see that despite Skidmore deference being a judicial tool, Customs has afforded itself Skidmore deference in certain rulings, citing to other ruling letters that it had ruled similarly. So Customs believes that Skidmore is an important deference, and it is an important deference. And we'll talk about a little later, but Lopez did not change. Lopez did not overrule Skidmore deference. Let's see. Next, so the next slide here, we're talking really quickly about Ford, and this is an example of the application of Chevron prior to Lopez. In Ford Motor Company, the Fed Circuit and the CIT had addressed the issue of whether Chevron deference applied to Customs interpretation of certain statutory provisions relating to preferences under NAFTA. The case focused on Ford's failure to submit a required certificate of origin within 1 year, which Customs used as the basis to deny Ford's claim. Ford argued that it should have been afforded the same certificate of origin waiver it could have gotten under the reconciliation program, and said that it was an impermissible construction of the statute to have essentially two different paths with two different requirements. In response, CBP asserted that its interpretation of the statute was reasonable because there was more procedural safeguards under the reconciliation program than there were under 1520, and allowing waivers under one and not the other was therefore reasonable and permissible. The court had to look at whether CBP's interpretation was entitled to deference, and it determined that the statute was ambiguous as to this issue, and ultimately found that Ford's or the government's interpretation of the two provisions, 1520 and reconciliation, was reasonable. And like I said before, interpretation of statute can be outcome determinative. Because it was reasonable, the government won the case. Again, so this case turned on Chevron deference being applied. Next slide. The next case, another good example of Chevron applying here is AD Honey, and both Ford and AD Honey they're highly complicated, complex cases, and to anyone who's interested in how deference works or worked, I invite you to read the full cases. But for our purposes here, the case involved domestic companies, including AD Honey, contesting Customs implementation of the Continuing Dumping and Subsidy Offset Act, or the CDSOA, commonly referred to as the Byrd Amendment. And under the CDSOA, domestic producers were entitled to distribution of collected anti-dumping duties and interest. But CBP interpreted the statute such that any delinquency interest would be retained and not provided to the domestic industry. The plaintiff argued that delinquency interest that accrue from late payments of anti-dumping and countervailing duties should be included, citing to the purpose and the language of the statute, and they argued was to maximize compensation for domestic industry. The government, for its part, emphasized that the CDSOA did not explicitly address whether delinquency interest should be included, again, setting up the Chevron two-step analysis, first showing that there was an ambiguity or silence. And then they argued that it was entitled to deference because its interpretation was reasonable. The court looked at the statute. Next slide, please. The court looked at the statute, agreed that it was ambiguous or silent, found that the government's interpretation was reasonable, and again, therefore, the government prevailed in AD Honey. One of the more interesting quotes, and I think this is, really kind of solidifies how powerful Chevron was, at least at the court level. And this is a direct quote. Even had the court concluded that plaintiff's interpretation of the statutory provision is the more reasonable, the court would still be required to accept the agency's interpretation if that interpretation also is reasonable. So under Chevron, you could come to court and you could provide a more reasonable interpretation, but you would still have lost because the government only had to be reasonable. Didn't have to be right, didn't have to be the most reasonable, didn't have to even be the best construction of the statute. Next slide, please. The next one is another good example of Chevron deference being applied, and that is Graham Engineering versus United States. In this case, the issue revolved around Customs Service denial of an unused merchandise drawback claim. Graham Engineering had sought the return of 99% of its duties, filing a protest after Customs initially denied the claim. Denial was based on Graham's failure to file a notice of intent to export as required under the applicable regulations. Graham challenged Customs' decision, arguing that the notice of intent to export requirement was unreasonable and exceeded customs authority under the statutory drawback provision 19 U.S.C. 1313 J1. Government argued that Chevron deference applied. The court applied Chevron deference and upheld customs interpretation as reasonable for several reasons. It found the requirement was consistent with the terms and purposes of the statutory drawback requirement. Customs needed this notice to prepare the necessary procedures for inspecting merchandise to confirm its eligibility for drawback, something that would be impossible without the notice. Finally, the court found that the requirement did not place an unreasonable burden on drawback applicants. This again demonstrates how Chevron deference allowed agencies like Customs to interpret statutes within their scope as long as their interpretation was reasonable, aligned with the statutory framework, regardless of whether their interpretation was the best interpretation of the statute. Next slide, please. While the government has always been a fan of Chevron, and I can say that from experience, for 15 years, I was a very large fan of Chevron myself, as well as Skidmore and our deference. But Chevron has not been without its criticisms. As you can see, based on just the 3 cases we discussed, Chevron deference was broadly applied to a whole host of customs issues, NAFTA, CDSOA, drawback, and generally to the government's benefit. However, some argue that it granted agencies too much power, potentially undermining the judiciary's role in interpreting laws. Again, when you're in court, it's for the court generally to determine what the law means, and it's for you to argue that your facts fit within the bounds of that law. But when you are allowing essentially the government to construe the ambiguous statute, they're kind of taking over the judge's role in that sense. Critics also has asserted that Chevron allowed agencies to shape congressional intent without accountability. This can be problematic as it may enable agencies to interpret ambiguous statutes in ways that substantially influence policy, sometimes far beyond what Congress may have intended. Indeed, the Supreme Court had started signaling a potential shift away from Chevron even before the Loper Bright case. For example, the courts had shown a reluctance to apply Chevron in cases involving major questions, those with significant economic or political impact. Next slide, please. Actually, for example, one example I guess we did not put in the slides is a case called King v. Burwell, and that was the case involving an IRS created regulation for Affordable Care Act tax credits, and also West Virginia v. EPA, a case regarding the EPA's authority to regulate greenhouse gas emissions. The court in both instances was hesitant to defer to agencies when issues involved very broad social or economic implications. And this trend reflected the Supreme Court and other courts a growing perspective that agencies should only wield the interpretive power when Congress has clearly granted them the authority to address these types of major issues. So there was already, leading to Loper Bright, there was already a pullback from both lower courts and courts of appeals on whether or not Chevron was going to be applied, and that leads us to Loper Bright. And Loper Bright was a Supreme Court case from earlier this year that tackled the application of Chevron deference in a dispute between the fishing industry and the National Maritime Fisheries Service, or NMFS, which is a part of the Department of Commerce, National Oceanic and Atmospheric Administrations. The main issue was whether the NMFS had the authority to mandate that certain fishing companies pay for government-required monitoring services. At the heart of Loper Bright was the question of whether Chevron deference should still apply when an agency interprets an ambiguous statute, particularly when significant economic or political implications are involved. And as we just discussed, there was a shift away from applying Chevron in such cases. The fishermen argued that Chevron should not allow agencies broad discretion to interpret statutes in ways that impose substantial new costs or obligations on private entities, especially without clear congressional authorization. Next slide. In Loper Bright, the Supreme Court ultimately sided with the fishermen, marking a significant shift in the application of Chevron deference. The court ruled that according to the Administrative Procedures Act of 1946, courts are required to decide all relevant questions of law when reviewing agency actions. This implies the court should rely on their own judgment interpreting laws rather than deferring to agencies' interpretations. Essentially, the court found that Chevron deference contradicts the bedrock principle of judicial responsibility. The court also highlighted a critical flaw in Chevron, noting that relies on the assumption that Congress intended to delegate interpretive authority to agencies when laws were ambiguous. The court argued that this assumption doesn't reflect reality and goes against traditional roles of the court. Indeed, an ambiguity could just be poor drafting, not really a intent to allow the agency to have more discretion in how they apply the statute. Now, importantly, this decision did not overturn past cases that relied on Chevron. Those decisions would need to be challenged individually. Further, the court reiterated important that the agency interpretations may still qualify for Skidmore deference, which again depends on the agency's expertise and the persuasiveness of its reasoning rather than its binding authority. Further, Loper did not overturn our deference, which was deference to agency's interpretation of its ambiguous regulations. But many question ours in continued viability, as the arguments in Loper to overturn Chevron are just as applicable in our deference cases. Next slide, please. So, begs the question: what would Loper Bright in its reversal of Chevron, would that have impacted any of the cases that we discussed? And honestly, it's really very hard to tell. But one thing we can say is that the plaintiffs in A.D. Honey, Ford, and Graham Engineering would not have been having to prove that the government's interpretation of the statute was unreasonable, which is a difficult thing to do. What they would have been free to do is they would have been free to say, listen, even if the government's argument or our interpretation is reasonable, it is not the most reasonable. It is not the best interpretation of the statute. And you would have been in a position that you'd have more arguments, and I think you'd have a better chance of prevailing when, again, you're not trying to prove the unreasonableness of a government position, just that there is a more reasonable interpretation. Next slide. One case, that folks have asked me, well, is there any case that's a good example of one that would likely be decided differently under Chevron versus under Loper Bright? And the one case that has always jumped out at me was a case called Butler versus the United States, which was a challenge to the revocation of a broker license for failure to file a triennial report. The broker in that case argued that his license could not be revoked because his revocation was only possible after the 60-day grace period following the receipt of a notice required by statute. Now, CBP argued based on its own regulations interpreting the statute that the 60-day period began to run not on the date it was received, but on the date the notice was mailed. CBP argued that the regulation was a reasonable interpretation of an ambiguous statute because otherwise a broker could avoid revocation by moving and failing to update their address. Now, interestingly, this case was not decided, but it was actually transferred for lack of jurisdiction. The CIT doesn't have jurisdiction over this issue, and I tried to follow the case, through its ultimate disposition in the district court, and it looked like it was resolved out of court. But I could easily see under Chevron a court finding that the regulation was reasonable because the government has a reasonable point. If a broker doesn't change his address, he'll never be able to be served with the notice. However, post Loper, it doesn't matter whether the government's argument is reasonable. Is it the best interpretation of the statute? And the statute in this case is very clear that the grace period begins upon receipt. So you have a statute saying receipt, you have a regulation saying mailing. So I think this factual circumstance highlights a particular circumstance that would be decided differently. Next slide. I wanted to mention also quickly Como Tire. The facts of this are not particularly important, but this is one of the first cases decided by the CIT post Loper Bright. It was a foreign tire manufacturer challenging the Department of Commerce's determination that the acquisition of certain land use rights and the undervaluation of currency by the Vietnamese government constituted countervailable subsidies. A key issue in this is whether the Court of International Trade needed to interpret Vietnamese law independently, de novo, or should it defer to Commerce's interpretation. Now, the court specifically mentions and cites Loper Bright and reaffirming that it now, post Loper Bright, has to independently determine the proper construction of law. It is no longer required to defer to the government's reasonable interpretation. But it was careful to also acknowledge that Commerce interpretation may still be entitled to Skidmore deference, because, like we said, Loper Bright did not overrule Skidmore. Next slide. So what does all this mean to compliance? Well, here's my first, as a former DOJ attorney who handled a wide number of penalty cases, premised on importers' lack of exercise of reasonable care. Loper Bright doesn't really change that. The importer's obligation under the statute is reasonable care. And that means you have to review and possibly comply with ruling letters that are on point. You have to comply with statutes and regulations. You have to comply with court cases. Again, Loper Bright did not reverse any previously decided court cases under Chevron. It doesn't change the fact that you'll have to be consulting with experts such as your broker, such as customs attorney. However, Loper Bright does have some important changes, and I think it's most impactful as an opportunity to challenge customs decisions, or as a defense to an administrative penalty. If you're facing a penalty or something of that nature, and is based on customs interpretation of your obligations under a regulation, you are no longer bound to the court's no longer bound to adopt customs interpretation, but is free to listen to an argument that there is a better interpretation of that statute. I also think that it's going to potentially change how careful customs is in interpreting statutes. I think it's going to be more careful in its writing of regulations to more closely mirror the statute. Again, it doesn't have this broad discretion to just interpret things reasonably. It's got to interpret things in the most appropriate, the most proper manner. So again, it's a complex issue. And again, while Chevron is gone, we still have our deference, we still have Skidmore deference, and we still have reasonable care. So it's certainly a sea change when it comes to customs litigation, but I'm not so certain it's going to impact in any material respect, customs compliance. Thank you. I'm looking at
Yeah, thank you, Jason. We got quite a few questions here. The one that always pops up when we were working on this particular webinar, and thanks Angela and Mitchell for putting this together, was a question about tariffs. Like, how does that fit into this whole discussion of, because most of them go through Commerce or some of the agencies. Does that fit in there, or that's more the executive privilege?
Again, Chevron is going to, Chevron's gone now, but Chevron always popped its head up when there was an ambiguity in statute. So to the extent there's an ambiguity in some sort of statute under, for 301 or 232, and customs has interpreted it, that's when they would have gotten the benefit of, is there an ambiguity? Was our interpretation reasonable? And you know what, court? We don't even have to be the best. If we're reasonable, you have to defer to us. That's no longer the case. So when it comes to tariffs, when it comes to any sort of ambiguity in this statute, customs is no longer going to enjoy the benefit of Chevron deference.
Yeah, and so CBP has worked for the last 3 years on customs modernization, customs 21st century customs, and a lot of that has been built off existing legislation that's come out, everything going back to the Import Safety Act and all the other pieces. How do they need to go back to the drawing board on that, given what has changed since this has come down, or because it doesn't look like Congress is going to pass any customs reform bill in the next few years? So I
don't think they necessarily have to go back, because theoretically they should have been drafting regulations in accordance with the statute.
Yeah.
But what it means, though, is these regulations may be more ripe for a challenge, as not the most appropriate interpretation of the statute. And again, I note that when we're talking about the broker triennial report issue, that is still in the regulations. The regulations still say 60 days from mailing. The statute still says 60 days from receipt of that letter. And that, I think, is a prime example of something that may fall or ripe for a challenge, post Loper Bright. The government can't walk in and say, well, we're reasonable. They have to walk in and say, we are being truthful to the statute.
Okay. And then the last issue that comes up, forced labor. Where does that, all the social compliance interpretations, green trade, all of those that are coming down the road, how does that fit in with everything you covered today?
Again, deference has always been a court issue. When it comes down to day-to-day compliance, as compliance professionals, I would hate that we would be trying to figure out how a court's going to look at a regulation or a requirement and kind of roll the dice to say, well, I think at the end of the day, the court's going to find this to be unreasonable or not the best interpretation of statute. So in my mind, and as a litigator for 18 years in front of the CIT, deference really is a defense issue, a court challenge issue, but you don't want to be in the position of trying to guess whether the court is going to uphold a customs regulation once you're already in that position of being accused of some sort of 1592 penalty or something else. Again, it's just another arrow in our quiver to go back and say, customs, no, there's no violation here because your interpretation of the statute is wrong, your regulation is going to fall. But again, as customs compliance professionals, we still have to exercise reasonable care, and the reasonable care is going to be, the ruling letters, the court cases which have not been overturned by Loper Bright, customs regulations, informed compliance procedures, the tariff itself. Again, all those core materials are still going to, they still play just an important role. It's just that customs may not enjoy the level of deference when it comes to court action. Because again, if you're not going to court, customs regulations is what it is. You know what I mean?
Yeah. And you don't see any, what about the other, you talked a lot about customs, but what about some of the other participating agents like FDA, and have they used this to sort of in the trade space?
I have not seen it in the trade space with respect to the FDA, but again, the Cuomo tire, that was commerce.
Mhm.
And that's important to that they didn't get Chevron deference in that case. But again, the court noted that they're still entitled to Skidmore deference, and we can't forget that customs still has a level of deference that may be afforded to its ruling letters. It has a level of deference which may be applied to its interpretations of ambiguous regulation. So Loper Bright did not end all deference. It got rid of perhaps the highest level of deference, but there's still two alive and well deferences out there. And again, that's why I mentioned Cuomo tire, the CIT, letting everybody know that while we don't have to apply Chevron deference, we still may be applying Skidmore deference.
Okay. Jason, let's see if we got any, do we have any additional questions? This is not the last opportunity for you to ask, Jason, but maybe live. We're going to have the opportunity for you to provide questions after the webinar. Let's see if we have any. All right. Well, thank you, Jason, for the great presentation. This is very informative. The conversation doesn't end here. We would encourage you to continue the conversation. Oh, we have a question. All right. I don't see it in the chat. What's the?
Oh, I think I figured out the technology. I click Q&A.
Okay.
Should we in trade law be concerned about President-elect Trump's threat to massively change the scope of administrative agencies like customs in light of Loper? It would seem that a massive expansion of litigation over administrative decisions is certain, and that the courts will be asked to play an active role in in interpreting administrative law. I do think, one thing I mentioned that I don't think your responsibilities for customs compliance have changed, but I do believe that when it comes to litigation, this may spawn a tremendous amount more of litigation, because it's kind of up in the air, whether customs interpretations will be found to be the best interpretation, the most important interpretation. So I do believe that Loper is going to spawn significant litigation. I think there's regulations out there and things that are going to be happening that will be subject to litigation now.
Let's see, Angela, do we have any additional questions?
No, we do not.
And because this webinar was so informative, this webinar is
Well,
for NCBFA credit. So
I'm just curious, how others feel that Loper may have changed customs compliance. Maybe we can have a little bit of feedback. I'm not a customs compliance professional. I'm a CIT litigator, and I look at this as through the eyes of a litigator, that this means that I have a better chance of winning in court when I'm challenging customs actions. But I would love to hear what folks who are on the ground in companies that are doing customs compliance, how do they feel that this may change their obligations? If anyone wants to share.
See if anyone wants to put anything in the chat. I can't see the chat, Angela. Has anyone provided some feedback?
If anyone has a comment, just raise your hand and I will allow you to talk.
Oh, okay. We have Sue. Oh, this is good.
Eugene, can you hear me?
Yes, we can hear you.
Okay, great. I thought that was a very informative program, but I'm not sure it makes the world of difference that everybody's sort of anticipating, because the cost of litigation is so high and customs' attitude is to force litigation wherever they can to make life difficult for importers because they want to collect the money, that I think it's certainly another argument to be made when one looks at evaluating litigation, but I'm not sure it's going to add to the wealth of litigation. And I use the word wealth advisedly because it's just too bloody expensive to litigate, even if the court is, as it usually is, willing to ride circuit. So I think that the dollars and cents are going to win out in terms of, are you going to go to court or not? The length of time it's taking customs to issue rulings, the tortured reasoning to find 301 to apply, and all of those things, I think are going to be greater motivators to an importer in terms of what they choose to do or not do than this change. Now, there's an argument to be made that because the commerce regulations have been around for so long and they've been interpreted and they've been upheld, that at least when it comes to anti-dumping and countervailing duty, it's going to have even less effect. But, I think by and large, it's just cost of litigation is too high to make any of this worthwhile for most companies in most circumstances.
Yeah, that's an excellent point. I'm hoping that there's the wealth of litigation, but in a selfish note, but that is exactly right. It was one thing I'm cognizant of, that yes, the cost of litigation is somewhat prohibitive, even if you have a valid claim. My only point is, I think the government is more susceptible to challenge now than it was prior to Chevron going away.
Yeah, I don't disagree with you, Jason. I think it's a question of when you evaluate, if you've decided it's important enough and you're going to go to court about it, it's one more argument to be made, at least at the complaint stage and or the oral argument stage, depending on how things come up and how you choose to challenge them. But it's still a dollars and cents analysis.
Yes. Yeah, I completely agree. Anyone else want to weigh in?
We have another comment in the Q&A section, Jason.
Let's see. Oh, sorry. I'm looking at two different places. You got the webinar chat and then the questions and answers. Yes, this is, this is a great point. And somebody mentioned, for them, they don't want to end up in the CIT fighting customs. But it is another tool in the toolbox. And again, it's another tool that can be brought to bear at the administrative level as well. And arguments that customs is misinterpreting statutes or its regulations are susceptible to challenge. Maybe customs will take those arguments a little more to heart at the administrative process, understanding that that if it does end up in court, they would get a regulation determined to be invalid. So even if folks are not going to be litigating, I think it's definitely worth raising these type of issues at the administrative level.
Do we have any other questions? All right, well, thank you, Jason, for the informative program. Again, this program is going to be recorded, and as I mentioned earlier, it's been approved for NCBFA credits. We'll have our next webinar tomorrow, AI and tariff code classification, so make sure you use the QR code to participate in that program tomorrow. We want to thank Jason and STR, and of course, thank all of you for participating. And so everyone have a safe week, and we hope to see you tomorrow at the AI tariff code classification webinar. Have a good week.
Wonderful. Thank you, everybody.
Thank you.